And when everybody's set up, we'll take your appearances from left to right. Appearances from left to right. Your left to right.
Sorry. Ariana Reed on behalf of the Carrier Plaintiffs.
Thank you.
Brianna Switzler on behalf of the Quebec and the Wren Plaintiffs. Thank you.
Scott Cook on behalf of Speedy Mart.
Thank you.
Good morning, Joel Odou on behalf of FittedLifestyles.com Inc. and Real Water Inc. Also online is Nathan Carlson from my office.
Any other appearances?
Your Honor, this is Teddy Parker. I don't know if you can hear me.
I can.
Good morning. I apologize, Your Honor. I'm not on video. I'm out of the jurisdiction. I'm actually in south of France, and so I don't have the ability to get on the video.
Oh, rub it
But
in, Mr.
I'm
Parker.
on the phone. I represent one of the plaintiffs in the Real Water case, so I'm just participating for that reason, Your Honor.
Thank you. Other appearances?
Thank you, Your Honor. Good morning. Colt Dodrill, Bar 9000, Counsel for Nevada Beverage.
Thank you. Other appearances?
Good morning, Your Honor. Daniela, LeBounty on behalf of Defendant Costco in the Cava matter.
Thank you.
Good morning, Your Honor. Scott Rasmussen, bar number 6100 on behalf of Hanna Instruments Inc., SID International, and SID US.
Thank you. Is that everyone? All right. It's the plaintiff's motion to request an order adding the cave parties to the coordinated cases. Ms. Switzer?
Good morning, Your Honor. As this court is aware, in May of 2021, thereafter, this court has ordered and agreed to stipulate, based off our stipulations, to coordinate for pretrial discovery purposes only the related real water matters in order to avoid unnecessary costs and delay and to kind of help things along in that matter. And we have appointed Special Master Hale as well to serve as the Special Master to hear all the discovery related matters. Even as Speedy Mart has conceded in their opposition, this is a related real water matter, and there's no reason that this also should not be coordinated to kind of further those same goals. By their opposition, Speedy Mart seems to request that the parties who have been conducting discovery in the coordinated matter should have to redo all of the same exact discovery and end up with the same exact discovery as the outcome, almost in an exercise of futility, simply because they're added in late. This plaintiffs have contended throughout the litigation that the real water was contaminated with a chemical called hydrazine, a rocket fuel propellant. And the only question that's unique in this matter specific to Speedy Mart is whether they distributed to the plaintiffs the defective product that they allegedly consumed. Other than that, the substantial amount of discovery has already been done in the coordinated related cases. So far at the special master hearings and at depositions, there are several defendants that are in similar position as Speedy Mart that have defended and asked questions and requested information in a similar, that have similar interest in Speedy Mart. However, there's, as they mentioned, there is a substantial amount of information. However, that would not change in conducting their own discovery or in not coordinating these cases. If Speedy Mart has determined after looking at all the depositions that it seeks to do a second deposition or anything like that, it's not without remedy. We have a special master for this very reason. They can make a request of the special master that an additional deposition could be taken, and any non-duplicative discovery that has already not been completed, that can be before the special master, and any concerns there have been addressed. Speedy Mart also asked that if our motion is granted, which we already obviously it should, that this court should require all evidence be relied upon at trial be identified now, regardless of whether or not it's been identified in the other cases or the coordinated cases. Such a request is not only devoid of legal support, but kind of runs afoul of the pretrial disclosures anyway, and they will have that remedy at the time when it is pertinent. Right now, we don't even have a trial date in the Quebec matter, having to specifically identify all the documents now that we have to use for trial would be prejudicial and not seek to aid in the furtherance of this case in any way. So for those reasons, Your Honor, and I know we have a briefing on this as well, which I think is, if you have any other questions, I'm happy to do so, but for now, that is.
No, thank you. And Mr. Cook, your opposition, please.
Good morning. It is interesting to hear the take that's being presented because that isn't correct. Let's take a step back on this one. There hasn't even been any type of EC disclosure in this case. There hasn't been any compliance. Yesterday we had a hearing with Judge Kushner who said this is an exception. You did not bring Speedy Mart into the consolidated cases. We were left out because we had just joined the case. And the background of this case is simply that none of what was said this morning is accurate. What we did do is when we were asked to join the coordinated cases is write a letter to counsel saying, we're okay with that, except we're just a retailer in one case with one set of plaintiffs. All we ask is that you identify that this is related to Williams. We never got a response. We never had a 2.34. All we got was the opposition that was filed with the court. So the bottom line is this, when it comes to this, is we don't have any, any particular objection to being coordinated. All we ask is that we now have, as we join the case, Halo advised us that we have 89 gigabytes of documents. The plaintiff says, dig in, it's all there, figure it out. If I did 20,000 documents a day, it would take years to get through all the documents over the past 2.5 years. All we are asking for is that they be identified specifically to the Williams and the Cava case as they are filed so that we don't spend our time reviewing all of the case matter. As the plaintiff concedes in their response, most of this, in fact, almost all of it, has nothing to do with my client whatsoever. It's an unfair and inappropriate burden to place them in a position of trying to review everything. It's got a relatively easy remedy. We have never objected to it. And the interesting part when I look at this is that we are now 2.5 years down the line. We want to get on board with this. We have every desire to go forward, but we have a desire to go forward in a rational and reasonable way with my client's involvement, not to become involved in all of the cases, all combined, and try and figure out what's going on. And that's the reason that we asked that we have that designation there. We don't object to the coordinated cases, never have. We never have asked all the documents be done, all the depositions be redone. We've never asked that. We know where the resort, what we can resort to if we have a special master. All we ask is that we have a simple designation that designates our case as one that's being filed, so we don't have to deal with all the rest of them. Thank you very much.
Thank you. And the reply, please.
Good morning, Your Honor. Again, Brianna, Switzler. It's interesting that they say they don't ask for anything when their opposition specifically says that the court should order that Speedy Mart may depose any witness with relevant or discoverable information, regardless of whether that has already been disclosed in connection and engage in any other discovery allowed under the court rules. You know, I understand what they're saying in a way, but the rules are adequately already there. We have, they just did on Monday a demand for prior discovery. We're working on that. We'll be able to get that to them as soon as we're able to. Monday, 2 days ago. We're working on that. Already in the Speedy case, we've done plaintiff fact sheets, which have been done in the coordinated rail water cases. It consists of 76 questions, identifying who, when they got sick, the purchases, where they purchased it, the amounts allegedly consumed, their medical history, along with all of their medical, everything medically related that we have in our possession has already been produced as far as the plaintiff specific and above and beyond what's already been permitted, or, you know, without seeking the relief before the special master of that non-duplicative discovery. It seems like they want to redo discovery so that they know exactly what is happening in the case. However, it's going to be the exact same. Most of the documents have been produced by Real Water, part of their 16.1 disclosures. That's not going to change here. So we would request that there already, or we would suggest that there's already rules addressing all of the concerns that Speedy Mart has. We will follow the rules, and we would ask that this be our simple request of them coordinating a Real Water related matter be granted.
Thank you. It does make sense to keep this in with coordinated cases. but I'm going to tailor the order in a way that I hope will protect the defendant here. The motion will be granted. The plaintiff to identify the documents they believe are relevant to any defense Speedy Mart may have. And second of all, the special master, and I want this included in the order, special master may have the discretion to consider efficiencies that may minimize any potential prejudice to Speedy Mart. Any questions, either of you?
No, Your Honor.
All right, so Ms. Switzer to prepare the order, Mr. Cook to review and approve the form of the simple order. Anyone else wish to sign off on the order?
Not necessary for real water.
Good enough. Then thank you all for your appearance today.
Thank you, Your Honor.